it's clear, it's clear then that you're following the procedure under the contract. That's what the contract provides to do. But you can see the importance of the time limits. And again, just to reinforce the point that if you are in a termination circumstance, then the need for swift action, the need to be decisive is very, very important. Termination for cause under JCT. So non-compliance with the required procedure will make the contractual termination potentially ineffective, which will lead to repudiation arguments. Special care must be taken to ensure you can prove the specified default or necessary circumstances. For example, insolvency, you have complied with the necessary notice provisions under the termination clause, and you've allowed for the cure period to expire before issuing the final notice. Proving a specified default is often hotly disputed. That's definitely the case and has been my experience, particularly in relation to failure to progress the works regularly and diligently is usually a very that the interpretation of what that means is commonly disputed. There was a good case on that. Previously, it was the case of Vivergo versus Red Hall. Now, in that case, Vivergo were the employer and they had contracted the mechanical works to Red Hall. So what happened was Vivergo wrote a notice to Red Hall and asked them to rectify various defaults. So gave them a notice of default, and basically also to improve performance, because at that time Vivergo had Red Hall in Vivergo's view hadn't been adequately resourcing the project. So what happened was, before the cure period, the 14-day end period ended after Red Hall had received the default notice, Vivergo terminated. And unfortunately for Vivergo, the court found that Red Hall were entitled to rectify, and they were entitled to, or that Vivergo didn't have authority to terminate before the 14 days had expired. Now, what happened then? And also, what happened was that Vivergo, once they issued the default notice, they actually barred Red Hall from the site and said that you were no longer, entitled to come on site to complete your works. And the court found that it was actually Vivergo who had repudiated the contract by barring Red Hall from continuing their works. And it was in fact Vivergo who had actually repudiated the contract and were found to be liable for the damages that followed. So again, it's just a case that emphasizes the importance of the cure period, and also the importance, if you read that case, I mean, it gives some insight into, what are the grounds in relation to failure to carry out the works regularly and diligently. It is very rife area for dispute, because it's so subjective. So if you want to know more information on that, do check out that case of Vivergo versus Red Hall. Okay, termination for cause under JCT contracts. So specified defaults under design and build contract, which follows a very similar wording to the building contract. The contractor specified defaults are listed under clause 841. So these are without reasonable cause, wholly or substantially suspending the carrying out of the works, or fail to proceed regularly and diligently with the performance of his obligations under this contract, which I just discussed in relation to Vivergo versus Red Hall. That's it's a very subjective ground, and you need to be sure that that the contractor has in fact failed to regularly and diligently progress. A key reminder, I suppose a point that to make as well is that just because the contractor may be in delay, that of itself is insufficient to say that he's failing to regularly and diligently perform. You got to look at other grounds such as having inadequate resourcing on site, or persistent delays in relation to key elements of plant or equipment that need to be brought into the building. That just shows that he's that he's not planning the works effectively. But again, these grounds of themselves are for the most part insufficient to prove failure to regularly and diligently complete. You need to look at the circumstances in the whole in order to be able to satisfy the grounds for termination. The next ground is the refusal or neglect to comply with a written notice or instruction from the employer, which requires them to remove any work materials or goods not in accordance with the contract, and by such refusal or neglect the works are materially affected. So that's usually a clear one, because the employer in his default notice will specify exactly what he believes to be any work that is not in accordance with the contract. And I mean, obviously the contractor is he needs to act quickly on that, because if he fails to action it within the 14 days, or at least respond to the employer, then he's going to be at risk of termination and the losses that follow, which will include losses, as I said earlier, the additional cost to the employer that he will have for employing another contractor in his place. Fail to comply with clause 3.7, and this is the requirement for consent to subcontracting, or clause 7.1, which is a prohibition on assignment. Finally, a failure to comply with clause 3.25, which is a failure to work in accordance with the CDM regulations. A terminating party must take special care to ensure it can prove the specified default. And again, the reasons I said above, some are very clear, others are subjective and become a hotbed for dispute. Okay, so JCT termination provisions during the COVID-19 lockdown. So a force majeure event could suspend performance of some or all of the contractual obligations of any party affected by the event. If the UK government was pushed to exercise statutory powers to, for example, force a shutdown of construction sites, this act also has the effect of suspending performance of the works. Clause 811 of the unamended JCT standard building contract provides for termination by either party by reason of force majeure, or if the works are stopped by reason of statutory power. Under the JCT, the right to terminate will arise if the carrying out of the whole or substantially the whole of the uncompleted works has been suspended for the period set out in the contract particulars, which is generally 2 months in the which is 2 months in the unamended contract. But this is frequently being amended in new contracts which parties are entering into, since we started to feel the effects of COVID-19. So that 2 month period has been extended to 3 months. It can be even 6 months in some circumstances. So, I mean, when you're looking at future contracts, you are as well to extend that period because of uncertainty as to whether hopefully there is not another, what we call a second wave. But again, you want to make sure that you've catered for it in the contract. And in these circumstances, it is better to be safe than sorry. Safe than sorry. If the period is suspended due to a force majeure event, either party is entitled to notify the other that, unless the suspension ceases within 7 days of receipt of the notice, the contractor's employment may be terminated on the service of a second notice, which is given upon the expiry of the first notice period. Yeah, I actually had this when I was working as a QS. The project I was working on was suspended because of an issue related to planning. Now that project was actually suspended for 12 months. Now we were aware that we could have issued a termination notice after 2 months, but at the time we were in ongoing dialogue with the contractor, and we were happy to not terminate, but effectively agree a deed of variation at the time to wrap up the first phase, We actually, we were using the force majeure and termination provision to our advantage in order to, to get a better deal for ourselves effectively. But just be aware that ground does exist. I mean, if the contract has been suspended for 2 months, the contractor or the subcontractor, they can serve the notice to, to terminate. You can't be held to your bargain forever. So it's just have an awareness of it, and if you end up in that circumstance, how to use it, to use it in your favor. Okay, a recent example of termination gone wrong. So the issue of termination was discussed recently in the case of PBS and Ergo versus Bester Generation. Now, both parties here actually alleged a valid entitlement to terminate, with both parties each serving notices of termination. The court was concerned as to which notice of termination was effective and valid. Now, PBS sought to terminate on the basis of a lack of payment for a particular milestone. The court found that PBS's entitlement to terminate under the contract had not arisen. In contrast, Bester, who had been in delay and had their own issues on the project, they issued its own contractual notice of termination based on PBS's failure to comply with a notice to correct substantial breaches of the subcontract regarding ongoing delay with the civil's design and an abandonment of the works, evidenced by the issuance of the PBS notice of termination. And in the case, the court found that there was no need to consider common law repudiation. The contractual notice and its grounds were sufficient, and that the termination notice issued by Bester was in fact valid. That on a strict interpretation under the contract, Bester's contractual notice was valid, and again, regardless of the issues around Bester and their previous conduct, and also in relation to lack of delayed payment on that one, it didn't matter. The determination was construed strictly under the termination clauses that had been agreed between the parties. So again, it just sends it's just a word of warning to bear that in mind. Performance otherwise is largely I guess put to one side, and the termination is viewed on its own merits under the various provisions of the contract. So do be aware that's not new law. That's been the position for quite some time, but it serves as a timely reminder. Okay, so we're going to wrap up now. So concluding thoughts are whether under contract or common law, termination of a contract is risky and is likely to result in a dispute. Termination warrants careful preparation. Record keeping is key, particularly in relation to those grounds of failure to progress the works regularly and diligently, and those other subjective grounds that are commonly drafted into our our standard forms of contract. Contractual provisions offer more certainty, but proving the necessary facts can still be challenging. Knowledge and use of contractual notices of intention to terminate can be a useful strategic tool to compel action, even if this is not followed through. So the default notice is a very effective way for employers to, get their contractor to stand up and take notice of any defaults that are ongoing, because the cure period is only 14 days. So he's going to expect, where he may have otherwise requested a contractor to take action, that default notice is a very good tool for the employer to use in order to get the contractor to take notice. Because if the contractor fails to take notice, then if the 14-day cure period expires, then the employer can validly terminate and pursue the contractor for damages, which include the increased cost of completing the works. So, very important point to remember for employers if they have a contractor who is not adhering to notices, and a very good tool to have up your sleeve when it is you're dealing with termination. Okay, so that's it. Look, hope you enjoyed that. Hope you found it of interest, and thank you for bearing with me. And look, if you have any questions, I'd be happy to take them now.
We do have one question which was pre-submitted, Conor.
Yeah.
And someone had asked, what is meant by the phrase, "we are not afraid to walk away," but when it's said by various parties to the contract, so if it's said by an architect, by an employer, by a contractor, or by a QS?
Yeah. I mean, again, it depends on the terms, Julie. You know, if a party you're in contract with says that to you, then you've got to be thinking. Well, what does the contract in fact say? Because obviously, I mean, if he's thinking of walking away, then he must be citing some clause in order to be able to terminate. I mean, he must be thinking he's got a ground under his contract to terminate, and the ongoing event, whatever that is that event is ongoing. So my advice is, you know, if one of the parties does send that message, then you have to check your contract, because I think he's got to be referring to some clause. And it's very important that, again, like I was saying earlier, you've got to, when dealing with termination, you have to take swift action here, because you can't just ignore that, because under the contract, if time passes by, he may in fact have grounds to terminate and just effectively walk away from the contract, which you may not want, because if he does that, then you may have to go and employ another party to carry out the works or service, and it may result in you having to spend more money. But because the architect or the contractor has validly terminated, you can't recover that money from them as a result. So you're going to be stuck with the loss. So again, the need for swift action is very important there.
Okay.
Yeah.
Someone else is asking, what is specified default and insolvency?
Okay, so specified default, I mean, these are generally defined under the construction contract. There'll be various events, like I said earlier, is that failure to progress the works regularly and diligently, failure to carry out the work, or failure to adhere to the CDM regulations. Another example is where the contractor may have carried out works which is not in accordance with the contracts. Those are specified defaults. And you see, when you issue a notice, when I say default notice, that is a notice by the innocent party to say that you are in breach. You've committed a default under the termination provisions, and basically that you have 14 days to put it right. And that's the key to the default notice. But you see, some of where the problem occurs there is that some of the grounds are very clear. Just say some of the work was not in accordance with the contract. I mean, if the innocent party writes and says, you've installed column X that's not in accordance with the contract, it's very clear what he's talking about, and it's very clear what you have to put right. The problem is, the problem is if you get a default notice that says you're failing to regularly and diligently progress the work. You see, that's a matter of opinion and is largely subjective, which the other side are going to dispute. So it's much less clear under that specified default ground, which which is why disputes in relation to termination are so common, because some of those grounds bring in so much subjectivity, and parties become so entrenched, because invariably the relationship will have broken down, that that both parties just will dig their heels in, knowing in fact what the position is if they get it wrong most of the time, and hence why a dispute will occur. I mean, I've yet to see, you know, a termination happen where the parties were getting on really well and everything was going according to plan. I mean, it has to be taken that if you're talking about termination, the backdrop has to be that there has been a breakdown in the relationship, and either one or both of the parties want out.
Yeah. Okay.
Yeah.
Another question, in relation to contract termination from completion of your obligations, is it necessary to record the closure of the contract through a formal document or termination agreement?
You can do both, really. I mean, if the parties are agree to terminate in relation to contract. Sorry, I'm just reading that back, Julie. So I mean, like, if you've completed your obligations under the contract, then your contract will naturally come to an end anyway.
So you don't need to formally record the closure.
Not, I mean, what you'd want to record in those circumstances is the date you achieve practical completion, because that will set off the that will begin the process under the contract where, you know, you have practically completed your works. The defect liability period will commence from that point, and various other issues such as release of retention come into play as well. I mean, so I wouldn't say there's a need for a formal document to record your practical completion. An email is generally sufficient in the circumstances, but it's very important to get it in writing. That's
okay.
Key.
And what amounts to acceptance of repudiatory breach?
Acceptance of a repudiatory breach is basic. Like, a repudiatory breach is obviously a breach that goes to the root of the contract. I mean, so if the employer writes to the contractor saying that the contractor is in repudiatory breach, then the contractor is, he has the option of accepting that repudiation. I mean, it may be for various reasons that that he might just not have the resource. I mean, so it does happen where a contractor will want out, and you will see the effects of where a contractor will want out for. I mean, look, in most circumstances, in this case, is that the contractor he's experiencing severe cash flow issues, and he may just come forward then and say, look, I am having issues. I can't resource the job. I can't get labor. I can't get plant. I can't get materials. So you can accept, but I mean, it will prompt a dialogue. I mean, and really the acceptance should turn into to a negotiation as to in relation to the breach and be embodied in some form of document. I mean, it's very rare that the acceptance of the repudiatory breach is in fact accepted just on the face of it, because you want to say yes, you want to say, yeah, I can accept, but look, I think it's better if we walk away and negotiate a settlement and do it on that basis. It just helps to avoid future notices of damages and losses that can flow as a result of the repudiation.
Yeah. Okay. And what if a main contractor engages another subcontractor due to the previous subcontractor walking off site and stating he will not return? Would that be acceptance?
Main contractor engages another subcontractor. I mean, before the main contractor, I mean, if the subcontractor has walked off site and said it will not return, then I mean, that's clear grounds for failing to progress the works regularly and diligently. Now, before, again, if that has happened, the employee, like the main contractor, should be writing to the subcontractor to confirm that and record it in the default notice immediately. Because again, thinking of about your grounds for termination, you want to have given your notice, and you want to have allowed the 14-day cure period. I mean, if it's
same person saying that, would that be acceptance, but under common law?
Would it be accepted under common law? It's again with common law, it's risky. I mean, would it be acceptance? I mean, look, by his very action, he's failing to progress the work still regularly and diligently. But like I said earlier, it's just a much riskier way for the main contractor to try to terminate. If you can follow the contractual procedure, issue your default notice, wait for the 14 days to expire, then on day 15 issue the termination, then engage your subcontractor. I mean, I'm not sure about what the time lag here, but I mean it's very rare that that you'd have a subcontractor lined up to come on and replace another subcontractor the day after they may have stated that they would not return. I mean, the common law is a much riskier procedure to try to follow. And again, like I said earlier, the consequences of getting it wrong are significant.
Huge. Yeah.
So if you can go contractual, go for it all. My recommendation would be to go for it all day long. It is the much safer way to do it. Follow the timelines, and you're much safer. You can then progress with your new subcontractor with confidence. The last thing you want to be in is in a position that you've engaged this new subcontractor, and you don't have any certainty as to where you stand with the old subcontractor. Because it's very hard to make commitments on the back of uncertainty that goes on in the background, as well as the distraction and invariably the dispute that's going to happen. So yeah, for all those reasons, I'd be recommending to follow the contractual procedure as much as possible.
Okay.
Yeah.
And that seems to be the end of the questions for today. So thank you everyone for attending. As I say, the recording of this will be available on the website later today. If you have any specific questions for Conor's email address, which is on the materials and on our website, ConorAhern@silverllp.com, and I know Conor will be more than happy to answer any specific questions for you. So thank you very much, Conor, for a very interesting chat this morning. Thank you everyone for attending. Those of you that are attending the insolvency and cash flow later on today, we look forward to seeing you then. So thank you very much and stay safe, everybody.
Great. Thanks, everyone. Bye now.